Hello, everybody. Welcome back. I'm so glad that you're all here today for another Justia webinar presented by Justia Connect. If you haven't met me yet, my name is Marina Wilson. I'm a member of Justia's marketing team as well as a lawyer, and I'm here to help kick off today's presentation with a few quick notes for you. The first thing being that for all of you that are here looking for CLE credit, you need to remember that that is only available for Justia Connect Pro members. So if you're attending on a Justia Connect basic membership, that free level of our membership, then you would need to upgrade to Justia Connect Pro to be able to get CLE credit for today's webinar. The other thing is that if you are looking for CLE credit, then you will need to stay for the entire duration of this program. Now, I'm going to turn things over to my moderator and colleague, Nina. She's going to help kick off today's presentation and introduce today's speakers.
Thank you, Marina, for welcoming all of us here today. My name is Nina, and I'll be the moderator for this webinar. To start out, I wanted to give a bit of background on our speakers, Vikram Amar and Michael Dorf. Vikram Amar is a distinguished professor of law at the UC Davis School of Law and a professor of law and former dean at the University of Illinois College of Law on the Urbana-Champaign campus. Before beginning his previous role as dean at Illinois Law in 2015, he was a professor and administrator at various law schools within the University of California system, including the UC Davis School of Law, the UCLA School of Law, UC Berkeley School of Law, and UC Hastings College of Law. He has penned several books and over 75 articles in leading academic journals focusing on constitutional law, federal courts, and civil procedure. He earned his BA from UC Berkeley and his JD from Yale Law School. Prior to entering academia, Professor Amar clerked for Justice Harry A. Blackmun of the U.S. Supreme Court before joining the law firm of Gibson, Dunn, and Crutcher. He was the first person of South Asian heritage to clerk at the Supreme Court and was the first American-born person of Indian descent to become a dean at a major American law school. Michael C. Dorf teaches constitutional law, federal courts, and related subjects at Cornell Law School. He has authored or co-authored 6 books and over 100 scholarly articles and essays for law journals and peer-reviewed science and social science journals. He also writes a bi-weekly column for Justia's Verdict and publishes a popular blog, Dorf on Law. Dorf received his undergraduate and law degrees from Harvard. The webinar presentation you're about to see will be approximately 1 hour, and Vic and Mike will be taking audience questions after the presentation is complete. If you have any questions that come up during the presentation, please feel free to put them in the Q&A button at the control panel at the bottom of your screen. Without further ado, here are Vikram and Michael to discuss 2023-2024 Supreme Court term preview.
Thank you so much, Nina. It's a great pleasure to be here with my good friend Vic, who is also writes a biweekly column for Justia's Verdict. We've been doing that together for a great many years now, and we nearly always agree, although occasionally we disagree, and maybe we can find some areas to disagree about today. So today is the second Wednesday in October, which means that although we're calling this a preview of the Supreme Court term, the term is already underway. It started on Monday of last week, the traditional first Monday in October start. But there are still a whole lot of cases of great importance to be argued. And of course, the court hasn't decided any of the cases that have been argued since last Monday. Just to give you a sense of what we're going to do, I'm going to give you a very brief overview. Then Vic will chime in on that. Then he's going to lead us off with a discussion of an important Second Amendment case. We'll then talk about a bunch of administrative law cases, some First Amendment cases, and a tax case, and then we'll get to questions and answers. So that's a lot to cover, so I'll just jump right in with a brief overview. So the last 2 terms of the Supreme Court were clearly blockbusters. 2 terms ago, the court overruled the longstanding constitutional right to abortion in the Dobbs decision. It also expanded the right for gun owners to possess handguns in public. Last term, the court reversed course and disallowed virtually all race-based affirmative action in higher education, even while not officially overruling some of the leading cases. This term, I don't think there are any hot-button social issues quite on a par with the last couple of terms, although there are a number of important cases that follow up on some of those issues. There are cases in the pipeline that could present follow-ups. There are very important cases involving the scope of administrative agency power. And as we'll see in the first case that we're going to discuss, which Vic will get to in just a few moments, the court has a very important Second Amendment case that follows up on the decision from a couple of years ago, figuring out how to apply the court's test for deciding whether a restriction on firearms possession is constitutional or not. So that's basically all I want to say by way of overview. I'll turn it over to Vic to see if he has any additional thoughts on the term as a whole, and then to introduce the Second Amendment case.
Thanks so much, Mike, and our Justia host. It's a pleasure to be with you, Mike, and to talk about cases. I think I agree generally with what you said about this term, except that as lawyers, and most of our viewers are probably lawyers, we know that sometimes the most important cases aren't necessarily the ones that are grabbing headlines for lay people. And so cases that you're going to, I think, introduce involving the administrative state are hugely important. The Second Amendment case I'll turn to in a moment, I think is a real kind of turning point, or it's a fork in the road for the Supreme Court compared to the Second Amendment cases it's decided so far. And let's also remember this is the term leading into a presidential election cycle, which traditionally the court has tried not to decide, blockbuster cases that it didn't have to. But I think, it may be that the court gets dumped on with some cases relating to the election that we don't even know about yet. Cases that might arise out of efforts by states to keep former President Trump off the ballot under Section 3 of the 14th Amendment to the extent that he engaged in rebellion and the like. So I think when we do a review, as I hope we'll do next summer, I think we're going to have a lot of interesting stuff to talk about. So with that, let me turn to the Second Amendment case you adverted to, and that's the United States versus Rahimi. So Zaki Rahimi is a guy in Texas who was convicted of abusing his girlfriend. He knocked her to the ground and dragged her in a parking lot and hit her head against the dashboard of a car. A few months after that, a Texas state court entered a domestic violence restraining order against him. And that order also barred him from possessing a firearm, which would be a felony for someone under a federal law that says while you have a domestic violence restraining order under you, you're not allowed to possess a gun. About a year later, while the order was still in effect, he was a suspect in a couple of shootings. Police got a warrant, searched his place, and found, among other things, firearms and ammunition. He was charged with the federal law that bans possession of firearms by anyone who's subject to a domestic violence restraining order. He pled guilty because there really wasn't a lot of facts to be determined, and was sentenced to over 6 years in prisons, followed by 3 years of supervised release. The Fifth Circuit Court of Appeals, which is generally a pretty conservative circuit, initially upheld his conviction, but after the 2022 New York State Rifle and Pistol Association versus Bruin case that Mike adverted to in the blockbuster term 2 years ago, after they struck down New York's public carry law and laid out a very originalist, historically focused test for determining all Second Amendment rights, the Fifth Circuit reversed course. And under that test that the U.S. Supreme Court laid out, lower courts are no longer supposed to balance individuals' Second Amendment rights against government interests. They're supposed to ask instead the historical question whether there was a tradition of prohibiting firearms back when the Second Amendment became law, analogous to the prohibition that is at issue today. The Biden administration sought review and argued that depending on how you look at it, there's always been a tradition that government has disarmed people who pose a significant safety threat to others. And under that test, they thought that Rahimi, his conviction should be upheld. He, of course, resisted cert, and the Supreme Court nonetheless granted cert, which I think is a little interesting given that only 2 years has elapsed since Bruin. And oftentimes the Supreme Court likes to let lower courts kind of work through a new framework or a new test for a while. I'll just have three quick observations, then I'll turn it over to you, Mike. One is, I don't know what's going to happen here. I wouldn't want to make a prediction. I don't, even though a lot of people think under the originalist conservative historical test, this conviction's in trouble, I'm not so sure of that. And that leads me to the second point, which is Any originalist test has to grapple with the level of generality at which you ask the historical question. If you ask, were there laws prohibiting people with domestic violence restraining orders against them from getting guns? Maybe not so much, but there weren't domestic violence restraining orders back then. If you ask what the federal government asks, were there laws prohibiting people who had been adjudicated to be dangerous, especially with respect to certain other known individuals, can they be deprived of guns? Then it's a very different historical answer. So even though everyone is an originalist of some sort, the level of generality question is something that we need more information on on this court in general and on the Second Amendment in particular. The other point I guess I'd make is that this is really the first big test case for the Second Amendment, by which I mean the three other cases in which the court has struck down a law, Heller involving the District of Columbia Ordinance, McDonald involving a similar ordinance in Chicago, and then Bruin in New York. All of those cases involved invalidation of what we might call outlying laws. Very few other jurisdictions besides D.C. and Chicago had the kind of handgun bans at issue in Heller and McDonald. And as the court pointed out in Bruin, New York was one of only 6 or 7 states that was doing what it was doing, and it wasn't going to be too hard for New York to come into the mainstream. But this is an issue that I think matters to a lot of people. This is a more core question under the Second Amendment, whether dangerous, convicted, violent individuals can own guns. So with that, let me turn it over to you, Mike, and see what your thoughts on the case are.
Yeah, I guess I want to make a point about the level of generality question and sort of flavors of originalism. So in the early days of the sort of modern originalist movement, people talked about seeking the original intent of either the framers or the framers and ratifiers. And then over the last 30 years or so, partly due to Justice Scalia, partly due to pushback from others, most serious scholars who call themselves originalist moved off of original intent in the sense of subjective intentions and expectations and towards the public meaning of the words. What's interesting, I think, about New York State Rifle and Pistol against Bruin is that it seems to be more of an original intent or expectations test, right? That is, we don't ask, and the court isn't asking, what was the semantic content of the word arms in 1791 when the Second Amendment was ratified, or in 1868 with respect to a state law that's incorporated, where the Second Amendment is incorporated by the 14th Amendment. Rather, the court is asking for traditions of prohibition, and that's certainly relevant to what the framers and ratifiers of the Second Amendment might have expected. It's not necessarily relevant, although it could be, but it's not necessarily relevant to the meaning of the words. And so I think this is an area where there's a possible divergence between sort of scholarly defenses of originalism. In my view, the most defensible versions of originalism focus on original meaning, right, the words, as opposed to subjective intentions and expectations, which have all sorts of problems about aggregation and so forth, right? So there's a difference between the scholars and the judges and justices. Interestingly, one hasn't seen that much divergence on the particulars. That is to say, most people who call themselves originalists have, for the most part, been supportive of the court's Second Amendment jurisprudence, even though, certainly especially after New York State Rifle and Pistol and against Bruin, the court has diverged more towards the original intentions position. One way that I think the court could step back a little bit in this case is to de-emphasize expectations at that very specific level of generality that you were talking about, Vic, and move more towards the words. And that way, I think they'd have a sort of face-saving way of saying, hey, we're not crazy here. We're not invalidating and these laws and arming all of these potentially very dangerous people.
Right. The only thing I would, I think that's all really helpful. Remember as well that the Bruin reformulation of the test, was an experiment of sorts. So I think the court itself didn't know exactly how all this would or should play out. So I think the court has a little bit of running room to kind of tweak whatever it announced in Bruin, so to give more guidance. without, as you say, kind of losing face in their general originalist orientation. So, why don't I introduce the first of the administrative law cases, and then I'll kick it over to you to introduce some others. There's a case that, again, it seems kind of technical, but again, lawyers and people who study government will realize the question it presents is quite fundamental. It's Loper Bright Enterprises versus Raimondo. The narrow question presented deals with a pretty arcane federal policy requiring owners of fishing vessels to make room on those vessels and paid salaries for federally required observers who, while the vessels are at sea with the fishing crews, collect data and monitor various actions by the crew in order to allow the relevant federal regulatory agencies to enforce whatever limits on different kinds of catches are in place, et cetera. So it doesn't seem like that big a deal, observers and who pays for them, et cetera. But the Supreme Court reached out and formulated the question that it wants to address in terms of something very significant, namely how much leeway or deference administrative agencies have to interpret statutes under the so-called Chevron deference standard. Chevron deference goes back to a 1984 case, Chevron versus Natural Resources Defense Council. And Chevron has since been interpreted to mean that when an agency interprets its organic statute, the terms of what Congress enacted, as long as its interpretation, which often goes to the scope of its own regulatory power, often the interpretation involves whether an agency can regulate something and in what ways. As long as the agency's interpretation of the statute is a reasonable one, even if it's not the best interpretation in the sense that it's not the interpretation that the court would otherwise put on the statute, given the general understanding of the words and or legislative history for those justices who think that matters, and the overall structure and statutory framework, even if the agency's interpretation is inferior to some other interpretation, as long as it's a reasonable interpretation, it warrants deference and the courts follow it and permit the agency to operate under it. And Chevron deference has been a darling of the more conservative justices beginning in the 1980s. Indeed, a lot of the architects of Chevron and related deference doctrine were people like John Roberts, who were young lawyers at the time working in Republican administrations at a time when the Democrats were winning Congress and the Republicans were winning the White House, and administrative power was kind of where conservatives were able to make their mark. But now there seems to be a general disfavoring of broad discretion by administrative agencies on the part of the conservative wing of the court. And if I had to predict, I'm relatively confident that Chevron deference will not survive, at least in the form that it has been understood so far, that it'll either be eliminated or reconceptualized and trimmed back significantly. I think part of that relates to developments in the so-called major questions doctrine that the Supreme Court has undertaken in recent years, suggesting that the court is very reluctant to uphold broad delegations of authority from Congress to executive agencies. And when we're talking about the delegation to interpret one's own power, that's maybe categorically a broad kind of delegation of which we should be scared. So I think that the court will probably cut back or eliminate Chevron deference, except perhaps in the case where the agency's interpretation is at least as good as any other interpretation. Maybe it's not better, but as long as it's no worse, if it's just in equipoise, maybe the agency gets the benefit of that tie. But certainly, if there are other interpretations that are better, I'm not sure the agencies will warrant that kind of deference. I am not upset about that in the abstract. I've always been a critic of Chevron. I think it's weird for the actor who is exercising power to be able to determine the scope of that power. I think when laws are made in the United States, they're made by the House, the Senate, and the President. But when laws are interpreted by agencies, they're done by only the executive branch, headed by the President. And in an increasingly unitary executive world, the agencies' administrations may align with the president's policies. And because the House and Senate don't have an easy time reclaiming power that was given to an agency, because the president wears two hats in this business, he gets to veto laws that might want to cut back on the discretion that has been given. I would much rather have courts who have no conflict of interest in the game than agencies who might have a systematic tendency to overread the scope of their own power under statutes, make those decisions. So it does trouble me that conservatives have done a 180 on this, but I want to be more consistent than they are, and so I'm okay with revisiting Chevron, even though I understand that there, in certain settings where agencies have technical expertise, there might be other reasons for granting deference. So I'll kick it over to you to give your piece on that, and then introduce some other cases.
So thanks very much. So for those of you who are very interested in this, Vic has a really interesting column that he wrote for Justia's verdict. That's part of the written materials. I urge you all to take a look at it. I'll just say that I'm a little bit less skeptical of the Chevron doctrine. So when I teach my federal courts class, one of the questions we ask is, how do you reconcile Chevron, which seems, as Vic says, to give law interpreting power to agencies that is only reviewed deferentially by courts, with Marbury against Madison, which says it's emphatically the province and duty of the judiciary to say what the law is. And the usual way in which we reconcile this is we say that when Congress writes an ambiguous term, we can think of it as delegating power to the agency to go up to the edge of that ambiguous term if it wants to, but not beyond it. So just to take Chevron itself. So Chevron, as Vic is indicating, was actually a conservative decision ideologically. It upheld the Reagan administration's less aggressive interpretation of the Clean Air Act than had been used by the Carter administration. And the operative term there was the word stationary source. Question was, did that refer to the entire power plant or to individual smokestacks, as the Carter administration had said, within a power plant? And the way I think of this is, without violating the Marbury principle, is that by using that ambiguous term, Congress was delegating power to the agency, not to say that what the scope of its power was, but to choose a regulatory policy within that band of what could reasonably be called a stationary source. Now, in order to get that out of Chevron doctrine, I admit you have to do a lot of fancy footwork. And it's also somewhat inconsistent with another case the Supreme Court decided some years later called Brand X, in which they said, well, if an agency hasn't construed the statute, then the courts get to say what it is, but then the agency gets to go back again and say what's in that scope. So I think reasonable minds can differ as to whether, as a matter of first principle, Chevron is sensible, it's consistent with the role of the various branches. But what I'd like to say, after I give Vic a chance for a sort of surrebuttal if he wants, is that I see the effort to cut back on Chevron less as this sort of, principled reevaluation along the lines that Vic has identified, than as part of a sort of suite of decisions by the Roberts Court to make it just much more difficult for federal administrative agencies to exercise power. And while that could be justified, I think, in sort of constitutionally neutral terms, or we want Congress to legislate, my sense is that there is at least a soupçon of hostility to government regulation, full stop, on the part of, what is, after all, a conservative court. So, Vic, I want to give you a chance to respond to any of that before I go on to the next cases.
Thank you for plugging my piece. If people are interested in kind of my longer version of my critique of Chevron, they can read that. I do share your concern about motivation. And I think I would even add to it, it's not just kind of an anti-regulatory instinct, but I think it's also a reflection of the conservative/Republican recognition that it's going to be increasingly harder for them to win presidential elections going forward because they just are losing the popular vote. And although the Electoral College, provides pathways for popular vote losers to win, when the popular vote margin increases, and it seems to be increasing in favor of the Dems most election. I mean, I don't know about 2024. That's kind of an unusual election. But in the long run, I think it's going to be harder for the Republicans to count on heading the executive branch, and so defanging that branch is not something that is without a conflict of interest there. So I share your concern, but I guess I want to take the high road and just stick with what I've said all along.
Great. Okay, I'm now going to talk pretty quickly about 3 other cases that present issues involving the permissible scope of agency action. So one of them was argued last week on Tuesday. It's Consumer Financial Protection Bureau against Community Financial Services. So you may recall the CFPB was created by Congress in the aftermath of the 2008 financial crisis. It was originally the brainchild of Elizabeth Warren. It has been a bit of a political football. Democrats want it to be aggressive. Republicans don't like it. And it's already been the subject of one Supreme Court decision involving the Constitution. That's a case from 2020 called Seal of Law against CFPB. In that case, the court struck down the independence of the head of the CFPB. They said that it's okay to have an independent agency, that is to say, an agency headed by people who can't be removed at will by the president, who can only be fired for good cause. But if so, that's got to be a multi-person agency. You can't concentrate so much power in just one person. And so they changed the nature of the head of the agency. This case is a different kind of attack on it. This is under the Appropriations Clause of Article 1, Section 9, which says no money shall be drawn from the Treasury but in consequence of appropriations made by law. The CFPB does not get its money by annual appropriations from Congress. Rather, it gets its funding from the Federal Reserve, subject to a cap. That is a percentage formula. Last year, it was apparently $734 million. And they get that money for their reasonable expenses. But the challengers, which are payday lenders who are subject to one of the CFPB rules, say, hey, that's not permissible. That's not an appropriation made by law. Now, of course, immediately you say, well, wait a second. Are they saying that all money spent by the federal government has to come out of an appropriation specifically by the Treasury? What about Social Security and Medicare, which are funded continually via a formula? What about the post office, which gets its money from fees? And the Solicitor General's brief and oral argument pointed to, dozens and dozens of agencies going well back to the founding that have been funded other than by annual appropriations, and moreover points out that military appropriations are time limited in a way that general appropriations are not. I guess what I'll say on behalf of Community Financial Services, which is the respondent and the group of payday lenders, is they made a really heroic effort to try to dodge all of these other agencies to construct a rule that would only apply to the CFPB, because I think they recognize that the Supreme Court is not about to invalidate the funding of, more than half of the federal government. And so they've got to find a way to limit this. My sense of the oral argument was that they didn't have 5 votes, but we'll see. Second, do you want to jump in on that, Vic?
Yeah, really quickly. I was kind of astonished by the brevity and cursory nature of the Fifth Circuit's analysis in invalidating an act of Congress or an agency created by Congress. I think this theory is exotic at best. In addition to the questions you posed about which agencies it applies to, there are a level of generality problems here too. How far does Congress have to specify who gets the dollars? Obviously, agencies can decide what to pay their employees without Congress approving each and every employee line item. So I think the whole thing doesn't make any sense. The only thing I'll say is, I have a lot of friends and family in the finance business, and they just hate the CFPB. And so this is really it's for some reason, this agency is really it's fired up opponents of regulation.
Yeah. One other interesting issue in the case is, even if you agree with the Fifth Circuit on the unconstitutionality, there's a question of remedy. Their remedy was to invalidate everything that the CFPB has done. Okay, let's take an agency that's a little more well-established. This is the Securities Exchange Commission. So this is a case called SEC against Jarkesy. It also comes out of the Fifth Circuit. And the SEC is empowered to bring actions against people who have allegedly violated various securities laws, either in federal district court or in agency enforcement actions. And here the Fifth Circuit invalidated the ability to go through internal agency enforcement actions on 3 independent grounds, I think all of which are somewhat dubious. So first, they said it violates the Seventh Amendment right to jury trial. The Seventh Amendment, as you know, preserves the right to jury trial in civil cases at common law, where the amount in controversy exceeds $20. And the big problem there is an enforcement action by the government under a statute is not generally regarded as a suit at common law. Suits at common law are typically between 2 private parties. In this area of law, there is a gigantic body of doctrine distinguishing between so-called public rights cases, where the government is given pretty wide latitude to proceed in an agency, versus private rights cases, which are sort of more like common law cases, where you have to go in court and you get a jury. So I think on that ground, the court will likely reverse. Second thing the Fifth Circuit said is the violation of the non-delegation doctrine, right? This is sort of in the background of all of these administrative law cases. It's a limit on how much power Congress can delegate to an agency without specifying what the cases call an intelligible principle. Here, it's true. Congress didn't tell the SEC exactly when you have to go to court and when you can proceed in the agency, but that's not the kind of thing for which it's generally been thought in the past Congress needs to say. That is sort of thought to be within the general scope of prosecutorial discretion. I think the most interesting thing that the Fifth Circuit said was that the administrative law judges are invalid because they have removal protection via good cause, and they in turn can only be removed by the Security Exchange Commissioners, who themselves have removal protection for good cause. And there is a case from 2010, Free Enterprise Fund against PCAOB, in which the Supreme Court said you can't have 2 layers of good cause removal protection. So that sort of fits in here, although the Solicitor General argues, well, yeah, that's for people who are exercising executive power. You want an administrative law judge to be insulated from removal because you want them to be fair and not subject to executive override. So I don't think that conventionally understood any of these claims is very good. But again, you know, it's possible the Fifth Circuit thought they were all good, and maybe the Supreme Court will disagree. Vic, you have anything you want to say?
Yeah, just quickly. So on the first point about the Seventh Amendment, yeah, it's been a long time since I taught civil procedure, but I thought Atlas Roofing and Brown Fancy, I thought that this is well-trod ground. That would be revolutionary to revisit that, I think. On the third point about removability, I do think it's interesting the difference between an ALJ and a core executive officer. In the 2010 case, the court did go out of its way to highlight how executive the power being exercised was when they struck down the 2 layers of protection. So I agree with you there. On the middle one about the non-delegation, I think things like the major question doctrine and revisiting Chevron are indirect ways of trying to vindicate non-delegation doctrine norms. And those indirect ways, I think, are the only things the court can do, because no one has come up with a test that will distinguish impermissibly broad delegations from necessarily generous authority creation and draw that line. So full frontal attacks based on the non-delegation doctrine, the court hasn't come up with a test that could really accommodate those attacks, which is why I think you see things like the major question doctrine and revisiting Chevron as second best options for trying to promote non-delegation ideals.
Yeah, I completely agree with that. Let me just say one more word about an administrative agency case, and then I want to move to the First Amendment area. So there's another case called Corner Post against Board of Governors of the Federal Reserve. And this is a very, very technical case that I only bring up because of its possible implications for another case that's in the pipeline. So the issue in this case is whether for purposes of essentially tolling the statute of limitations under the Administrative Procedure Act, a claim accrues when an agency issues a rule versus when a party is injured by that rule. And I don't have a view about what that is, this particulars here. I will say, though, that this could be very important for the case currently in the Fifth Circuit, challenging the approval of mifepristone with the so-called abortion pill, where one of the threshold questions is whether the plaintiffs in this case, who are doctors who are opposed to abortion and have a claim that they might have to perform an abortion for somebody or give medical care to somebody who took mifepristone, right, whether they are time barred. And it's possible, something the court says in this case, could have implications for that case if and when it gets to the court. Okay, let's turn to the First Amendment, where the court has two pairs of cases. All four of these cases involve the intersection of social media and free speech. So the two big ones that have gotten the most attention are cases involving state laws in Florida and Texas that differ a little bit in their particulars, but not in a way that need concern us right now, that forbid the big tech companies, basically Google, Facebook, and what used to be known as Twitter, now X, from two sorts of things. Various forms of content moderation, like labeling or banning and so forth. And they also require that when one of the social media companies either blocks somebody or labels a particular tweet or post as disinformation, that they provide individualized explanations to the account holder explaining why they did that. There are other provisions of the laws that are not before the court currently. But essentially what happened was the 11th Circuit struck down the Florida law, and the 5th Circuit upheld the Texas law, creating a circuit conflict. So it was inevitable that the Supreme Court would want to review this. I think there are really two sorts of questions here. Maybe there are more, but there are two main questions. So one is the editorial discretion that social media platforms use in arranging, allowing, and so forth, the posts of other people, speech, at least of the sort that you might think goes into the editorial discretion that a newspaper editor exercises, or given that it's done through algorithms and other things, it's not really any speech on the part of the platform, and that therefore, as the Fifth Circuit said, this isn't speech, this is just censorship. So there's a threshold question of whether the social media companies are themselves speakers. And, they're sort of in between. Everybody agrees that a newspaper, if told whose letters to the editor they have to publish, that's a violation of their freedom of speech. There's actually a case involving that, case called Miami Herald against Tornillo. Everybody also agrees that when the telephone company transfers your call from, California to New York, that it's not a speaker, it's just a kind of common carrier. And the platforms are somewhere in between. As I say, the 11th Circuit thinks that they're enough like editors to have speech rights of their own. The Fifth Circuit didn't think so. Second question is, even assuming that the platforms are speakers, what do we make of these restrictions? Are they content-based and therefore subject to strict scrutiny? Or are they merely sort of time, place, and manner restrictions saying, hey, you can't censor anybody, that sort of thing, and therefore subject to some lesser form of scrutiny, intermediate scrutiny is what has been said. Interestingly, the 11th Circuit, in striking down the Florida law, said that even under intermediate scrutiny, the law is invalid because there is not a sufficient interest in restricting the speech of the platform and giving individualized explanations of why somebody was barred or labeled or what have you, is just way too burdensome and is going to effectively chill their ability to have this platform and thus chill the speech of third parties. I'll say two more things, then I'm going to turn it over to Vic for commentary before I talk about the other cases. One is that, Justice Thomas has previously written that he thinks that these platforms can be, and maybe already are, common carriers. I'm not sure I agree that they are common carriers, but you could imagine regulation that was different, that would restructure platforms so that they would be more like common carriers. And that raises a question that's not directly presented here, which is, how does all of this interact with the congressional regulation we do have, Section 230 of the Communications Decency Act, which provides for certain kinds of immunity against state law. The second thing I'll say is that even though these cases code as conservative regulation, because it's conservative actors in Florida and Texas who want to restrict the platform because they see the platforms as censoring conservative speech, historically, that's not necessarily the way these things align. Historically, it's often been liberals and progressives who wanted to limit the power of corporations in the interest of extending constitutional norms to powerful private actors who sometimes have as much ability to squash what we think of as constitutional rights and interests as does the government. Okay, I'll stop there. Let Vic weigh in.
So I think that was a really helpful framing, Mike. On the first question you identify, whether the platforms, because they use algorithms, are not really speakers, I just think that is a non-starter. I mean, if to use your analogy of a newspaper editor, if a newspaper editor tells her underlings, don't accept any letters to the editor that proceed along the following substantive lines, we wouldn't say, well, the editor hasn't made a decision. So too, people choose the algorithms. The people who run these platforms decide which algorithms to use based on the substance of which kind of speech they don't want to host. So I think that it's clearly regulating something that is speech. I think the 11th Circuit opinion, by the way, for those who want to read it, is quite well done. Even before we get the U.S. Supreme Court opinion, I thought it was a very well executed thing. Which brings me to the second point, which is, is this really a content-based discrimination, or what kind of standard of review we should apply if the platforms are speakers? One has to ask the question why these entities and no other entities are subject to this. So there's always a content or viewpoint-based concern when you are subjecting only certain entities to regulation. So, for example, if we regulated electronic media in a particular way, newspapers, print media, or television stations, I think the Supreme Court would readily view that with skepticism. So I think at the end of the day, what it really comes down to is what you identified that Justice Thomas is talking about. Are these entities so dominant in the way we communicate that it's okay to treat them differently? And my response to that is I don't think they are, because technology evolves so unpredictably. The same kind of arguments were made for things like the Fairness Doctrine, which regulated broadcasters along the spectrum of frequency. And now in a kind of a post digital age, we realize, hey, the concept of airwave frequency is kind of antiquated. There's lots of ways for people to get their message out. Twitter becomes X. Maybe X will die. MySpace was big and it's not. I don't know that the platforms we have today are going to be the platforms we have tomorrow. They all will cater to different markets with different generations. So I'll be quite disappointed if the Supreme Court doesn't affirm the 11th Circuit in relatively straightforward terms, but I'm not going to make a prediction.
Thanks very much. And just to be clear, I was reporting the argument made rather than endorsing this idea that algorithms disable kind of editorial judgment. Okay, so I want to talk about two other social media cases. Their cases are Lindke against Freed and O'Connor-Ratcliffe against Garnier. I'm probably mispronouncing many of those names, but they're two cases that present more or less the same question. And that is, when you have a government official who uses their previously personal Facebook account for government business, not just government business. They also maybe post videos of their kid's birthday party, but also notices about what the government is doing about this pothole, or as in one of these cases about COVID policy. Is that the state action for constitutional purposes? And is it action under color of state law, which is the statutory requirement under the Federal Civil Rights Statute, 42 U.S.C. Section 1983? As I said, there are two cases. They're more or less the same. The reason they're both there is that we got different answers. The Ninth Circuit said that is state action, that is action under color of state law, and therefore, if you have a Facebook fans page on which you're posting this information, and somebody then criticizes you, you can't just censor them, you can't just block them, because it would be as though in the physical world, you had a public forum and you start censoring people who are making anti-government statements. The Sixth Circuit gave the other answer. The Sixth Circuit said, no, they're not state actors. This is not action under color of state law. And the reason, said the Sixth Circuit, is that nothing in state or local law required the government official to communicate with the public this way. This is just something that he sort of did on his own. The question in the case is, does that matter? If the government official chooses to use their private account to conduct at least some government business, does that not mean that now you've created a public government forum for speech? As many of you in the audience probably remember, this issue arose also during the Trump administration when President Trump used his personal account, which he had previously used and still continued to use, for all sorts of, personal and political messages, also to announce things that involve government policy. And the Supreme Court never fully weighed in on that. Now we'll get to hear it in this somewhat less weighty context. Before I turn it over to Vic for comment, I will note something very amusing about the case. So NetChoice, which is the industry trade group for the big social media companies, that is effectively the plaintiff in the Florida and Texas cases we talked about a few minutes ago, where Florida and Texas are regulating those companies. NetChoice has filed amicus briefs in both of these two cases involving the state action doctrine, saying basically, we don't support either party, but whatever you do, Supreme Court, whether you say that the government actor has created a public forum or hasn't created a public forum, don't blame us. We're just not responsible. So we don't care what you do. It's just not our fault, which I guess is what you would expect.
Right. You're basically saying whether or not they're state actors, we are not state actors. So the rules don't apply to us. I'm going to say only, I think these are very interesting cases. I think you have to create some space for a government official to do and say things outside of an official state action capacity. But the facts of these cases are going to maybe dictate which side of the line their particular actions here fall on. So I don't know what's going to happen, but I'm glad the court is at least moving in the direction of providing some clarity here. So I know we want to leave some time for Q&A. So let me put the last case on the table somewhat quickly, and it's a case that involves the taxation of income, although that may be slanting the outcome, but whether or not the federal government can tax you when you invest in a foreign company that is plowing back its profits into itself and not issuing dividends to you. Is that still an occasion the federal government can tax? And as it was argued in front of the Ninth Circuit, the question was whether income that isn't realized in the form of a dividend can be taxed under the 16th Amendment. And the Ninth Circuit said yes, and that was the question on which cert was granted. My brother and I, Akil Amar, we're filing an amicus brief, I think, if we get our act together this week, that says that the framing of the case is kind of missing the boat in the following case, in the following respect. Whether or not this stuff is income that can be taxed under the 16th Amendment, I think it probably is. But whether or not that's true, the federal government can tax it anyway because it's simply not a direct tax at all. The United States Constitution draws a distinction between direct taxes, which have to be apportioned among the states, meaning that the amount of revenue collected in each state under the tax has to be proportional to its population, and all other taxes which don't have to be apportioned. And the Supreme Court in the late 1800s, in a decision that's been repudiated by the American people called Pollock, kind of overread what constitutes a direct tax. And all of the briefs in the case so far, save for a few other amici, have ignored a late 1700s opinion called Hilton versus United States, in which the U.S. Supreme Court upheld a tax on luxury carriages against the challenge that it was a direct tax that had to be apportioned. All of this stuff in the case in Moore versus United States, it's all a prelude to the huge question that might come down the road: can the federal government impose a wealth tax? That's what this case is about. That's why an otherwise nondescript case is garnering some attention. So I think if for an originalist court to ignore the views of Alexander Hamilton and Washington and what all the justices who wrote, all four of them, a unanimous court in Hamilton said a direct tax that has to be apportioned is limited to a real estate tax, a tax on land, or a capitation tax where you're taxing people based on head count. Those are the only kinds of taxes that qualify as direct taxes. Any other tax is okay that Congress can pass as long as the same rate is applied across the United States. So I think this is a non-direct tax and should fly whether or not it's an income tax under the 16th Amendment. So let me stop there, turn over to you, and then you can weigh in, and then we can take some questions.
Yeah, so I basically agree with that. Let me just say, the petitioner's briefs are in, and the amicus briefs in support of petition are in. The government filed its brief at the cert stage, and so we have a sense of what they're going to argue. There is one brief already in on behalf of the government side, and that's by University of Texas law professor Cal Johnson, and he cites Hamilton extensively and makes a version of that argument. And in fact, what he says, I think, is quite straightforward. He says that the case from the 19th century, the Pollock case, that invalidated the income tax under the direct tax provision, was itself mistaken. So you never needed the 16th Amendment. And so he also says that therefore this old case called Macomber that the Supreme Court has distinguished but never formally overruled should be eliminated along with Pollock. So I think you're absolutely right. This is a good test of whether the justices who espouse originalist principles are really going to be guided by history.
And just one coda there. Pollock, the case that was wrong that triggered the 16th Amendment, was decided by the same court that brought us Plessy versus Ferguson the next year. And the Eisner versus Macomber case from 1920 was kind of smack dab in the middle of Lochnerism. So both of these cases involve the justices simply making stuff up. And again, if you're going to go against Abe Lincoln and George Washington and Alexander Hamilton and James Madison, who finally came around on the permissibility of the carriage tax, then it's hard to call yourself an originalist court.
Great. So we've reached the end of our affirmative presentation. Looks like we've got about 6 or 7 minutes left. Nina, do you want to fire some questions at us?
Yeah, thank you both so much for all of your insights. But for now, we can go ahead and jump into questions. Looks like we've already got a couple. Our first one is, if Chevron is overturned, will every regulation then have to be subjected to judicial review? That seems to be both extremely burdensome and inefficient. Congress has neither the time nor the expertise to develop detailed regulations.
So I'll quickly jump in on that. I think there are two parts to that question. First, if Chevron is overruled, that raises a question about what we do with all the cases decided up until now that relied on Chevron deference in upholding a particular regulation. And I think that's a complex question. And certainly overruling Chevron going forward doesn't necessarily require the court to disturb settled expectations with regard to those regulations that have been upheld under Chevron. The second part of that question I take to mean Is overruling Chevron gonna foist work on an already overburdened Congress to be more specific? And I guess I have a two-part answer to that. First, one, that's not such a bad thing if Congress does more of its job. And two, in any event, we're not necessarily pushing it onto Congress so much as moving it from the agencies to the courts, who will then interpret the laws on a clean slate and decide what they mean without regard to giving the agency's thumb too much weight on the scale. But I'll let Mike respond to that too.
Yeah, just on two things. So first, it's already the case that even without Chevron or with Chevron, all agency regulations of any substance are subject to judicial review. The Administrative Procedure Act provides for pretty broad standing for, quote, a party aggrieved to challenge agency regulations before they go into effect, right? It's unusual in that it's not the way that we think of our litigation system as generally working, which is after the fact, but rather, if you think that the agency didn't adequately respond in its final rulemaking to your comments that you provided during the notice and comment period after the proposed rule was promulgated in the Federal Register, then you can sue. And people do, and they can argue that the rule is arbitrary and capricious, and there are all sorts of ways in which agency regulations are subject to judicial review. So saying that they don't have the protection of Chevron, I think, would make them a little bit more vulnerable, but I don't actually think it would lead to much additional regulation. In the background of all of this, I think, is the question of why Congress delegates in the first place, because it does seem sort of contrary to the Madisonian notion of checks and balances, right? Madison had this idea that each branch of government would jealously guard its own power. Why are agencies giving away power to the executive branch? The conventional answer is, well, life has just gotten too complicated. Congress doesn't have the expertise. But there's a conventional question that then is asked, well, why doesn't Congress build up the expertise? That is to say, the kinds of experts that agencies hire could be hired by Congress too. They could have bigger agency staff. And so there's a puzzle as to why Congress has chosen to do that. I'll just say one interesting solution to that puzzle, just give me a second here, is proposed by my colleague Jed Stiglitz in a book and a series of articles. And he says Congress delegates to agencies because that way the agencies can gain the trust of the people through the processes of administrative law and administrative review. I'm not sure how persuasive that is. I think there's something to be said for that. Another view is they delegate so that they don't have to be on the hook for the policy choices that the agencies make. This was John Hart Ely's criticism of delegation. But there is behind this question of why is Congress doing that?
And a related question, Mike, of why is Congress doing it so much more now than perhaps 100 years ago? And maybe because some of the issues that are out there are so daunting, no one wants to own them because things are inevitably going to go south, and no one wants to be responsible for that. So there's one other one I'll let you take a stab at that Nina can introduce, I guess.
Yeah, absolutely. Last question here today is going to be, what do you think will happen with mifepristone, forgive my likely mispronunciation, in the future?
Yeah, so you may remember a federal judge invalidated the FDA approval for mifepristone, both the original approval and the subsequent approval for mail order. It's now on appeal as a temporary matter. The Fifth Circuit has stayed part of that. And so mifepristone is still available. This is the so-called abortion pill. I think there are really 5 questions here. So 2 of them are procedural. One is, do the plaintiffs, who are doctors who do not perform abortions, have standing? Because it's not clear that they're injured. They have this elaborate theory about how, given the practice that they do engage in, maybe someone who took mifepristone and had a bad outcome could come to see them, and then they'd be their patient, and they'd have a kind of third-party standing for them. The district judge and the Fifth Circuit accepted this, but it seems a little far-fetched to me. Second procedural obstacle is the one I adverted to earlier, which is whether these challenges are out of time. On the merits, there's the question of whether what is the level of deference to be given to the FDA, right? They did, after all, approve these drugs. There's a kind of substantive question about the initial approval. Then, with respect to the mail order piece, there's the validity of that, and also of whether that mail order approval preempts state laws that attempt to exclude mifepristone. And finally, even assuming that there isn't preemption by the Food, Drug, and Cosmetics Act, there is a dormant commerce clause question when states try to keep mifepristone out of state. This is an issue that I thought would have gotten more attention in last year's case involving California's application of its humane slaughter and pig raising law to pork products that were derived from out of state. But other than Justice Kavanaugh, nobody really paid a whole lot of attention to it there, but that could arise in the event that there isn't preemption. So I think that depending on what the Fifth Circuit does, there's a good chance the case could end up before the Supreme Court. And then I think all bets are off, because it's very hard to predict how the administrative law doctrine, standing doctrine, dormant commerce clause interact with their druthers about abortion.
Thank you guys so much. I know that, Vic, you have a hard stop, so I want to be respectful of that. We will go ahead and wrap things up. I'll hand things back over to Marina. Thank you both so much for your insights and your time.
One quick question, Nina. Does somebody at Justia own a corgi? Is that why we have corgi as the...
We've been doing dog-themed. As you know, Tim, our CEO, is a big fan of pugs. We started there and have just kind of branched out from that. Yeah.
Thank you, Mike. Thank you all.
Thank you, Vic. Thank you, Nina.
Great to be with you. Take care, everyone.
Bye-bye.
Now that you have learned more about the cases on the Supreme Court docket this term, we wanted to ensure you also know about free resources that can help you further your understanding and monitor ongoing developments in the cases discussed by our speakers today. Oye.com is a project bringing information on Supreme Court cases, justices, and more to the public in easy-to-digest and understand formats. It can be a great resource for getting that high-level overview of issues in a case, as well as diving into the advocates and justices. Information on select cases discussed by our panelists is already available at the links on your screen, and details on other cases will be added to the Oye site as the term progresses. Justia also offers free legal resources to the legal community. Using our Justia legal portal, you can access the circuit court opinions in many of these cases to get the background on the issues being appealed. The links to some of these opinions are currently displayed on your screen. And you can also access detailed information about cases before the court in the Justia Supreme Court Center. While limited cases from the 2023-2024 term are currently listed, more cases will be added as oral arguments continue and the term progresses. Of course, you can also continue to explore all of the free resources available at Justia.com to get a better understanding of what's going on in the different cases before the Supreme Court. And if you still need information outside of what's available through Oye and Justia, we encourage you to check out supremecourt.gov, where you can get information directly from the court itself about their upcoming docket, and scotusblog.com for additional details about cases before the United States Supreme Court. Yeah, thanks, Vic, for being here. And thanks, Mike. Thanks, Nina. And thanks to all of you. We're really glad that all of you were with us today. And we hope you enjoyed the presentation. I did see one comment there saying they're looking forward to the term roundup. So, I guess I take that as a good sign that this is a very interesting one for you guys. And then, of course, I want to make sure you're getting the most from your Justia Connect membership and everything that Justia has to offer. So that first thing to keep in mind is all members, regardless of whether or not you have the paid membership, are eligible to get our Justia daily opinion summaries. And with that, you can get summaries of new Supreme Court cases as the decisions are handed down. So you'll be one step closer to knowing what we're going to talk about in the preview. You can also get summaries of those appellate cases from the federal courts. So every federal appellate court, you can sign up for those if you would like, as well as the highest courts in each state, California appellate courts, and even summaries for your practice areas. So there's lots of information out there for free, and all you have to do is sign up for it. And then, of course, CLE. So as you know, that is a benefit for our pro members. Today's course was a CLE course. We also have a library of on-demand CLE courses and more CLE courses coming up in the future. So if you'd like to get some of that CLE credit, you can upgrade to pro. It is a very affordable membership. We have 2 options, a monthly payment or a yearly payment. Check that out at pro.justia.com because that's something else that you guys can take advantage of. Now, with all of that information, I hope to hear from you guys soon. I hope to see you all in our next webinar, and I hope you have a great rest of your week.